Thank you so much, Ruth. Thank you. So moderators that you were working with last week, they summarised the questions that you had, and we've asked some of the witnesses to provide written responses, which we'll add to our webpage when we've got a full set of those responses, and plenty of time for you to read through. The majority of your questions were to the first two witnesses on legislation, who we've invited back to respond to you directly. So thank you so much for this, and I'd like to first of all invite Polly Morgan to briefly summarise the questions and give you responses. Polly, if you can unmute yourself, and away you go.
Can you hear me now?
Perfect.
Lovely. Thank you very much for inviting me back. I've received 3 questions and a general request to add any further points in reply to Rebecca Bull, whose presentation I hadn't seen before my last one. So the first question is whether a change to the Gender Recognition Act would lead to changed wording in other legislation, or whether each piece of legislation would need to be changed. The second question is whether it's correct that exclusions are in place under the Equality Act for people with gender recognition certificates as well as without. And that is linked to the third question, which is about the conflict between sex and gender reassignment status. When an act is passed, it includes a list of consequential amendments to other acts. Some acts have many consequential amendments and some have only a few. Here, making it easier to obtain a certificate does not change the effect of having or not having one. That means that we would not need any amendments to the Equality Act. The Act is already drawn more widely than the Gender Recognition Act, because it allows you to exclude people on the basis that they are anywhere on the transition process. So it captures people who have got a certificate and those who have not. Remember that reforming the Gender Recognition Act does not change the overall number of gender reassigned people capable of being excluded under the Equality Act. There's no floodgate there. Now, the second question was, how sure am I about the ability to exclude those who have a GRC? Are they within the category of gender reassignment, or do they exit that category when they get a certificate? My view is that when a person obtains a certificate, they do not shed the status that allows you to exclude them as a proportionate response to a legitimate aim. That status being that they are gender reassigned, even though they have attained a different legal sex by having a certificate. I'm supported in this by 3 things. Firstly, that is the view of the Equality and Human Rights Commission, which has a statutory responsibility for the Operation Equality Act. Secondly, that is also the view of the Women and Equalities Committee of Parliament. Thirdly, I've read the parliamentary debates in Hansard from when the Equality Act was passed. The Solicitor General of the time said that a gender recognition certificate, quote, would obviously be covered, end quote, within the definition of gender reassignment in the Equality Act. What Parliament intended is relevant to how courts interpret statutes. And in the 10 years since the Act was passed, no practice has been different to that. Why have I only mentioned the Equality Act? Well, the Act addresses all legally recognised sex-based rights that I can think of, including armed services, maternity, etc., by creating a general right and then listed exceptions to it. There certainly were some specific sex rights. In family law, for example, and in criminal trials, women could use the legal defence of marital coercion, which was known as the "my husband made me do it" defence. But these were rightly abolished. You can also bring human rights damages claims against public authorities under the Human Rights Act. Now that brings me to the issue of relationships, specifically to the point that Rebecca has raised, that lesbians have been criticised if they don't want to be in a relationship with a trans woman. I've heard that too, but this is no aspect of equality or discrimination law. You're not employing them and you're not providing goods, services or facilities. There's no legal power to compel another person into sexual activity. Indeed, sexual contracts are illegal as a matter of policy, public policy. Indeed, it would be a crime to compel another person into sexual activity. So let us give that criticism made of women the disdain that it merits. Another issue is whether, if someone changes their legal gender, they are no longer a comparator for equal pay or sex discrimination purposes because they're the same legal gender as you. It's said that this will put a stop to almost all sex discrimination and equal pay claims. I don't believe this is true for several reasons. You don't always need a comparator in direct discrimination cases. But if you did, the claimant selects their comparator, and that person must not be materially different other than on the issue of sex. If you don't have a man to select as a comparator, or they are materially different from you in terms of length of service or qualifications, you could look at others with the same employer or funder who are doing like work of equal value to you, such as the female cleaners who used male refuse workers as their comparators in the Glasgow case. If you're still out of luck, the tribunal could use a hypothetical comparator. Now, it is possible that the only person with the same employer or funder who is doing like work and has no material differences such as length or service and qualifications is a trans person and has a gender recognition certificate making them the same sex as you and is therefore your comparator. That would be a problem because they couldn't be your comparator. And it would be a problem in the same way as only working with women would be a problem. But only about 0.005% of the population are trans women with gender recognition certificates. Even if every trans woman had one, that would still be only 0.5% of the population. So it may be a problem in a minuscule proportion of cases where they are your only possible comparator. But don't forget that the Equality Act has coexisted with the GRA for 10 years, and this has not been an issue in any case that I can find. Finally, any interpretation that prevented a whole class of people from having a remedy would fall foul of both EU law and Article 6, probably coupled with Article 14 of the European Convention on Human Rights. That's your right to determination of your civil rights and obligations, and your Article 14 right to not be discriminated against in the application of that Article 6 right. Given what I've said, I hope I have persuaded you that the legal issues raised against reform are not well founded. When one takes those away, what is left of arguments against reform? I suggest, respectfully, that the answer is there is no rational basis for objecting to it. Of course, that has not stopped the government, and neither has the fact that somewhere around half of trans people have attempted suicide. It seems to me that our treatment of trans people mirrors our treatment of other groups in history that we want to position as others. But I'm going to leave you to think on that and to listen to the other presentations. But thank you very much for listening to me and for taking part in what is a civilised and intelligent way of doing things. Thank you very much.
Thank you so much, Polly, and thank you for returning and answering those questions in so much detail.